Okay, then I'll get started. Welcome to the New Mexico Family Advocacy Program's 37th ECHO session. NMFAP is a model of respondent parent representation being implemented in the 13th and 2nd judicial districts that utilizes interdisciplinary teams of lawyers, social workers, and parent mentors working effectively together to provide quality representation and the advocacy and support families need for reunification or other preferred outcomes in the child welfare system. My name is Catherine Brock, and I'm one of the lead social workers for the New Mexico Family Advocacy Program. And Jen Vieira, did you want to introduce yourself?
Hi everybody, Jennifer Vieira, AOC. I'll be helping you all with tech support. Those on the phone, just remember to press *6 if you need to mute and unmute.
Thank you, Jen. Today's topic is mental health experts in child welfare. Just so that we know who is with us today, if you could please enter your name and email addresses into the chat. Please fill out the post-session survey, which is an integral part of our program's data collection efforts under the federal grant. The survey will only take a few minutes of your time, and Jen will post a link in the survey chat box. And we want to thank you in advance for any of your feedback that you are able and willing to give us. Today, our presenters are Susan Burns and John Duran. Susan Burns has been a clinical social worker in various mental health agency settings and in private psychotherapy practice for 35 years. She earned her Master of Social Work from Michigan State University in 1985 and did an advanced clinical fellowship with UNM programs for children and family and mental health from 1989 to 1990. Susan was a New Mexico State University professor for advanced social work practice and coordinator of the MSW Field Practicum program for 10 years. Susan was part of the initial collaboration to create the New Mexico Family Advocacy Program and has been clinical and program consultant to the program since July of 2019. Mr. John Duran is an attorney licensed to practice in New Mexico since 2007. He served as attorney for respondents and as guardian ad litem in children welfare cases as a contract attorney from 2008 to 2019, and continues as a child welfare attorney in his practice, in his private practice. John's practice has included family law since 2013, including services as guardian ad litem in over 75 family law cases in which he worked closely with mental health treatment providers. John has also included criminal law in his practice since 2015. John has litigated dozens of jury trials and bench trials involving medical and mental expert testimony. John also assisted in the implementation of the pilot project for the New Mexico Family Advocacy Program in Sandoval and Bernalillo counties. And I will pass it on to Susan and John.
Okay, so John, I'll run the PowerPoint, but you're jumping in whenever you feel like it, and whenever, so we'll do that. So I didn't realize that this was going to be called mental health experts, because it sounds like that's what I put myself out as, which is really just weird, as opposed to we're discussing the expertise of witnesses, but that's okay. Maybe a little bit one and the same. So thanks, John, for working with me on this. It's exciting. So this came about last year. I don't remember exactly when, and in fact, I see some of the people who were at that training a while ago when it was discussed whether, in fact, I think we were talking about what things you want to really make sure that your experts are discussing. And someone said, well, why don't you be an expert? And I said, well, I don't think that's something I can do, but let's talk about what it is you're going to look for. So that's what we're doing today. And John has been very helpful in working with the lawyerly aspects of what this is about and what it is that you have to, as attorneys, do all the time. So some of what I'm going to say may be redundant, because I think some of you have various ranges of experience. You know how to cross-examine. I don't have to talk about cross-examination. I like to talk about what are we looking to make sure that we've uncovered when we talk with people who are doing mental health work. And so please also, questions are fine. So, all right then, let me get in here. All righty. Can everybody see that? Yeah, yes, okay. Here's yes, here's no. All right, so we are talking about mental health testimony. So one of the things, and I have it's a little bit of a bullet later on, but one of the things that John helped me understand is, especially in this state, expert witnesses are generally the actual providers, the provider testimony in this stage, certainly because of just the perhaps insufficient amount of what might be, I don't know what would count as PhDs. I don't know what they think would be an expert, but that is really, that expert testimony in New Mexico is generally the people who are providing the work, right, John? Did I say that correctly?
Yeah, and I think that, I mean, there's obviously a lot of practitioners on here, attorneys that know not just that it's easier to access the expert who is involved with the case, involved with your client, but typically access to a specific expert, there's limitations to that, and access to the time that it takes to be able to find that specific expert. You know, a lot of times these trainings, in my opinion, they give you the checklist of everything you're supposed to do, and it just makes you worried about all the things you're not doing, as opposed to being practical on how to implement things. And so it's often good to just analyze whether or not the treatment providers in your specific case are good expert witnesses.
Okay, so let's start. And thank you to Leslie for helping a little bit to organize a little of what we're looking for. So I've broken this down into, this is the quick and dirty outline of what we're going to be discussing. The things that we would call perhaps more the legal aspects of the case. Remember that I'm telling you, you could tell me, the goal is bring the best foot forward for your client, and let's see if we can trip the feet of the people who are against your client. So that's what your options are.
Hi, this is Susan Burgess Farrell trying to reach Fernando Martinez. If you
Okay, I'm hearing somebody, so I thought they were talking to me. All right, so and then we're going to break that down into some. There. Uh-oh, I got muted. Does it say I'm muted? Can you hear me?
I think you were, Susan, but you're okay now.
Oh, okay. Thanks. Okay, well, I'm done. So now you can all go home. No, okay. So what are we looking for? What questions do we want to ask? What are the goals that the mental health person has, and what are your goals as the attorney? So we'll just move on to the actual PowerPoint. So the first part is using experts with, you want to use experts with favorable information to move your client, to move the case forward for your client, right? Duh, right? That's right. So so Leslie had questioned us, how do we get that information in front of the judge? But you also don't want to open your client to everything that's ever been said. So this is, I felt like this particular bullet point was the shortest, because in truth, everything that we'll talk about in terms of mitigating the negative information is just an opposite true for the people that you are calling up as witnesses, right? In terms of, so basically, can the provider give studies, readings, theories, models to support their positions regarding the child-parent relationship or the mental health status of the parent or child? And we will explore that as we move down into the PowerPoint. But essentially, if you're bringing somebody that you want to make a clear and good and lasting and winnable perspective, this is what you need from the person that's your witness. Are they prepared to back up with what they say they've seen or believe or assess or interpret with clear foundational material based in mental health work, which we will get into. So John, I'm going to let you take a stab at this.
Sure, and I think everybody, I'm looking at names, everybody's been in a situation, I believe here, that you get, perhaps you've qualified your client's provider as an expert, and you're getting into the nuts and bolts of what they were working on and the modalities that they applied to that structure. And there's testimony about your client perhaps being very disorganized, missing appointments or late. Maybe there's a history of physical, emotional, or sexual victimization, threats of harming themselves, or conflict at home. Those are all examples that come to mind when I can imagine asking my client's providers questions, and it gets into a little bit too much detail. And it's what you do at that point to clarify for the judge on what it is that they can, what it is that your client can do to be able to deal with that issue. And so, you know, and I don't want to take up too much time because this is a big topic, but you know, the use, of course, of rephrasing your question in a hypothetical is the benefit of having an expert. So just make sure that you are focused on whether or not, one, you need an expert. You know, does this provider need to be qualified as an expert to give an opinion, or are you using this provider as somebody who can testify and inform the court about, you know, your client's participation and willingness to participate in the therapy? But if you're looking, of course, for that expert testimony, then take advantage of what you have with expert testimony by presenting hypotheticals and how it applies to their modalities. So if you do open the door to negative information about your client, make sure that you're presenting that again, either on redirect, I think is more impactful after cross, but even on direct, make sure you use that hypothetical model to bolster the foundation of the provider's opinions by providing additional information that can remedy whatever negative information that came out. So you want to always just be prepared for that. If it was, you're usually only presenting an expert in a situation where there's the department does not see progress. You're not presenting an expert when it comes to, did they participate in treatment? So this is solely narrowed down to whether or not there's a question for the court on whether or not your clients made progress. So there's always going to be information that's presented that's not going to be 100% in the good column. So you want to fix any negative stuff that you open up to with those hypotheticals. I would also add, we kind of skipped over it, but there is quite a bit of thought process and case preparation that needs to go into whether or not you need to qualify a treating provider as an expert. There's still an opportunity, of course, under the rules of evidence that allow for opinions to be given by lay witnesses. Obviously, it's restricted by the rule, but before you even get to the point of qualifying an expert, make sure that you have talked to your client about it. Make sure that the expert or the provider knows that information ahead of time, that you're not just putting them on the stand and decide in the middle of it that you're going to try to qualify them as an expert to get an opinion. So just make sure that you review those rules ahead of time and obviously talk to your client. The preparation of an expert, I found, is more beneficial in cases where you have a client that is participating, that seems to be motivated for treatment. And if you can get the provider early on to understand that you're going to be checking in with them on the progress, on the work, on preparing reports, and you get that release from your client to work directly with the provider. If you get that early on, then you have that working relationship and you really serve as a guide for that provider. So if they're not comfortable in the courtroom, they already have you as their guide. And so there's a lot of ethical obligations that a treatment provider has when it comes to being an expert and whether or not they should be an expert. But you don't have to identify them early on as an expert, but I think it's important for you to know the providers from the beginning. And you'll know, I mean, everybody on here knows, I can see easily knows when your client is going to be somebody that's going to participate but may have issues with progress. And that's when you want to jump in early on, probably before adjudication or shortly thereafter, and making sure that you're getting those at least monthly reports, if not, maybe bi-weekly calls, emails to the provider, just asking how things are going, to make sure that you have that proper foundation as to whether or not they actually need to be called as an expert.
Yeah, well, great, because a lot of what you've just said, we're going to be looking into some more detail as we go on, is what is the person, how do you help that provider be able to articulate in favor, even if someone else can articulate against? So that's what we're looking for. And I would say as a therapist myself, I would say that it's hard to just get some succinct answers out of therapists. We do tend to want to go on and tell great stories. So that's not good. I know that in terms of court. All right, so then, and we'll talk more about that as we move into some of the other things. So just the second one is mitigating the unfavorable information. So, and the reality is that if you have the capable attorneys on the other side, which we do. And perhaps we have capable providers or people who are witnesses of some kind on the other side of the court. They will be wanting to do this to yours. So this is why I say you've got to have your person needs to be able to do exactly what you're going to perhaps challenge the other provider or the other witness on the negative side of the case. I might not be used very lawyerly terminology, so bear with me. Okay, so all right, so we just a little bit talked about the difference between a fact witness and the qualified expert witness, right? And what my thoughts about that are, I know yours from talking with John, facts versus interpretation and assessment. That boils down to the idea of the person being enlisted as an expert, I guess, is more likely to be able to share opinion than someone who is a fact witness. So this is where your work to understand what is that fact, how is that fact being interpreted by the people who are giving the fact? Is it being interpreted? Is the fact being interpreted by somebody, or is it just being given? But even if it's given, say the client said or did this. The client said the sky is blue. Well, facts, as we know, can be interpreted very differently by each viewer because look at all these blues here. That's a whole lot of different blues right there on the screen, which was completely accidental, actually. But so, well, that's not that. No, that's not it. So a fact is contextual. A fact is completely individualized by who is interpreting what that fact means to them or should mean to the client.
And Susan, if I may, I think
yes,
one of the issues that for the practitioner that you need to think about is whether or not the therapist is going to be able. Do you need the therapist or provider to say that your client was open to the process, talkative in sessions, committed to the process? You don't need an expert qualification for that. So that's all, as Susan was saying, that's all the witness's perception. What comes from that, of course, is an opinion. And if you're looking for that, then you need to evaluate whether or not you need to establish expert. In children's court, I think, as we all know, pretty much anybody can be an expert if you, lay out a little bit of their resume. There's been experts in pretty much everything from what I know. But in terms of evaluating whether or not you just need them to get your client's level of participation, not checklist attendance. Then I would caution trying to establish somebody as an expert if you know that there's a lot of that negative things waiting. If there's a lot of positive drug tests that are involved that maybe the therapist doesn't know about, or things that are going on with the client outside of therapy that the therapist doesn't know about, then you're opening the door, of course, for on cross for hypotheticals to be given to the expert that may change their opinion. But if you're looking just for really hyping up and establishing your client's participation, that's a good way to do it, is just leave out the expert and just talk strictly about their perceptions of how engaged they were.
Well, and since the law side of this is certainly not something I'm as familiar with at all, the other side, I would imagine, is pretty much doing the same thing. I mean, if they really don't want a child to be returned, then they're probably going to bring an expert forth, aren't they?
Yeah, that's correct. And then, and Kristen in the chat had a good question also in terms of, dealing with experts that are, thinking in the line of the direction of the department. And obviously, I think that's a whole different model of what we're dealing with in terms of when as a practitioner are we equipped to present our own expert. Again, I think everybody knows the avenue to ascertain an expert, but we're often limited in doing so. And so using the treatment provider that has worked with your client as an expert often can counter a department expert in terms of appropriate parenting or bonding experts that sometimes are really favorable for the department or really discourage reunification. your own client's provider can counter that by, of course, their knowledge. And that Kristen's question really goes more towards the preparation of your witness and your knowledge of what work they've done. So I think we're going to get to that in a bit.
Right, right. Okay, so just to continue on this business about facts versus interpretation, as students of mine would attest, it made me crazy for students to, when they were in master's programs, to use terms like, he said he felt bad, as if that was a statement of fact. So vague labels or descriptions, such as he felt bad. So I guess when I went about putting this together, I guess that what I was looking at was how do you know when it's time to challenge somebody? If you're hearing, and again, you guys do this. This is all, perhaps we're all highly skilled at this, and I can only come at it from the mental health aspect, from the therapeutic aspect. But so we need clear and specific descriptors. For someone just to say, well, he said he felt bad, tells us nothing, and they might believe the CYFD side of the equation may feel like that was sufficient information, in which case I would imagine that's where you jump in and say, what does that mean? Could you be more specific? I'm imagining here, in my mind, I'm pretending in my mind I'm a lawyer, wondering what would I say about that? So again, anybody jump in if you want to, or we just move on. So Jen, if I misspeak, if I present something that you think is just not really right, just don't hesitate to jump in. Okay.
Well, and again, understanding the modalities real quick, Susan, is that especially if you're, within the New Mexico FAP structure, you have, essentially your own expert by your side, your own social worker that can help interpret those modalities that are talked about for the expert. That all therapy is meant, to establish an issue and help resolve that issue. So if there is vague labels or descriptions like he felt bad, then make sure that you understand the modality that therapist or provider is working within, so that you're able then to address what tools they need to implement in order to establish the positive result that therapy is supposed to be looking for. Nobody walks into a therapeutic situation or treatment without the need for help. That's counterintuitive. So it's really about how do you address the modality given the disclosures that are made by your client.
Right. So by modality in this particular, you mean like whether they did a family or group, or the kind of therapy they were using?
The kind of therapy. Mm-hmm.
Okay, right. Good, because I'm going to talk about that too in a minute. So okay, and yes, you're right. So if I jump ahead a little bit, I'll see that in terms of just the legal aspects, is how do the lawyers in the program use the social workers in the program to prepare? And you just gave a good example of they hope they will be able to do their own thoughtful thinking about their analysis, their wondering about the strengths and limitations that they're going to see the person's therapist present themselves, and then help you find those areas where you're going to want to be challenging them. So back in here. Okay, so we just talked about this, that that we want the legal team is going to be looking for places where they're whether it's the CYFD worker, whether it's a provider who is going to be testifying to not bringing the child back into the home. Where are those? What are the models they've used? Thank you, John. You just covered that. So then I want to thank Peter Cooper for this, because a couple weeks ago we had him come. He talked about the SSI program, I believe. But one of the things he said was, if you want to be successful in a social security, in an SSI evaluation, you've got to bring content and skill, not passion and zeal. So I've reiterated that what is that professional opinion, whether it's expert or whether it's just functional, they worked with the client. What is their opinion based on? Is it what they believe in their heart should happen to a child and what they think is important, versus real challengeable skill with the DSM, which I will show you is this beast. This is the diagnostic and statistical manual in which every type of mental health possibility exists, and it's well, certainly you can't memorize it, but it's a beast. It needs a lot of hard work to be able to qualify someone as depressed or anxious, or is it this, is it that? And so that is, I think that's an easy place where people go to the same defaulted mental health labels. So when we want substantive professional training, and I also believe that we also need the relational expertise. So I've moved on to that to kind of talk a minute about the substantive knowledge that comes from professional training, whatever your profession is. There's data, there's formulas in the sense of, well, like I could just showed you the DSM. That's data, hardcore data. It comes from professional training, but it also can create a kind of a power and control situation where just data only sort of creates predetermined expectations and outcomes of what they think should happen to a client. So it's not client specific. It's almost more formula, objective data specific, as opposed to the relational knowledge that comes from the real cumulative engagement with clients, which I know the lawyers do, and I know social workers do. And I think probably from my witness so far, that I think social workers have perhaps more contact with their clients than perhaps even the lawyers do. And maybe that's an assumption that is not accurate, but lots of contact with the clients. And so having relational knowledge means that we know the client versus knowing the data. And to have that sort of relational knowledge helps the client grab resources that will make them more efficient and effective in their parenting, which is one way to get them back, and that's clearly known. I have a couple. This PowerPoint is available to you in your drive, so I threw in the sources of that information because that's the right thing to do, and they're interesting. So clearly, opinions and any opinion and decision made with just one of these kinds of knowledge is insufficient. It's inaccurate and it's possibly prone to bias. So whether it's conscious or unconscious, if you only have one of these, you don't have the whole picture of this client, this situation, this problem. All right, so the last piece of this one little section is, I've called it Beware the Eclectic Therapist. So an awful lot of mental health providers will say that they are, if you ask them what they do, what is their model, how do they work, they'll say they're eclectic. Okay, well, that's a real thing, but it also is in some ways kind of a little yellow flag for, do they really know exactly what those eclectic, what therapies are involved in their eclectic practice? Can they actually articulate the theories and modalities of the different therapies they use? And if they can't do that, then they're really treating very unsubstantially. They are treating without clear foundation or goals. And so when you mention that you want to know the modalities they're using, so I just put them here just kind of for fun. And these are the big ones. These are like the well-regarded ones from the beginning of, 80s, 90s into the 2000s. They are the very big ones that are used in our wazoo theories. And you can ask former students of mine, these are a lot of theories, and there's a lot of substance, and there's a lot of technique, and there's a lot of reasons and beliefs, and what are our goals. If you use this theory, what is the goal? If you use that theory, what is the goal? And they all have similarities, but they're all very different. And so if it might be interesting, because I guess what I'm hearing John say is, well, it's certainly possible that the attorneys that work with CYFD that are on the side of the wrong side of where you want to be, they might well ask your attorney, I mean your provider that you're putting forward as a witness of some kind, well, what is it that you use? If they were working with me, I would tell them to ask them what they're using. These are very specific ones.
Yeah, and
So,
Susan, I would also, I'm sorry, I would also
No,
add that, you know, as a respondent attorney, um, and even as GAL, you want to know ahead of time, early on, what is being used and what techniques and modalities and theories are being used for your client throughout the therapeutic process. I found that in certain cases, this has been very helpful for me to understand the work that's being done, so that when there is information that's provided, usually in court, that's negative about my client, there are, if you just understand sort of the basics, the basic outline as an attorney of how these modalities work, then you're able to structure either cross-exam or your direct exam of an expert based off of your understanding of these modalities. So if you get relapse, for example, which can often, you know, throw the treatment plan out of whack, a late relapse, then within the modality, there are possible solutions on how to deal with that. And so if you can really get your practitioner, your expert, to talk about how these modalities work with whatever negative information, a recent, perhaps a recent arrest or recent domestic violence or recent relapse, these modalities will be able to help you structure your cross-exam or your direct exam.
that makes me realize I left off alcohol and substance abuse. Certainly that's its own real world, and it has a little bit more in common with some of the motivational, solution focused and crisis work, but is definitely its own beast. So I'm going to add that when I get done with this. Okay, so at this, we're not going to be able to get into any of this, but in truth, I would be happy to come back and I'd be interesting to join some of the social workers that work with us in the program and come up with some interesting training on what that is, what they look like, how do they differ, how are they the same. So anyway, so eclectic is a question mark word in my mind, but I would even say perhaps that I was eclectic in my work, but I could tell you what were the theories that I used and pulled out when I felt this is needed here, but I could tell you why it was needed there and what I would do because of it. So if your witness can't do that, get them schooled, and if the other people aren't doing it, then challenge them. And I guess that would come, you know, again to, you'd have to hear something that felt like they were insufficiently prepared or insufficiently detailed in their descriptions. Okay, so then we had, again, this is sort of the lawyerly question here, is clarifying legal principles around sharing, admitting, objecting to mental health expert information. So, and John, when you said that you don't want to take up too much time, in truth, this is a big question. I mean, we might go at this several times, and we may not get to the end of what I wanted to bring as the mental health, you know, consultant to the program. But this is important stuff, so I don't object to anything. Just go. Do you want to speak about this at all? Whoops. Do we need to know anything about this?
Well, I think that that's a very detailed, a detailed bullet point. But what I would say is that there's been a lot of good, actually recent, fairly recent now, 2021 already, but case law on this issue, and I would certainly at least point any attorney to the. In fact, I'll put it in the chat. But it's the Strach case. It's 2015 Supreme Court case. Really good discussion on the legislative intent of privilege. An expert within the abuse and neglect world. Although it's a criminal case, they do touch on mandatory reporting and who qualifies for that, and whether or not there's privileges with treating therapists. Now, obviously, within that court, as we've been practicing, is that the treatment therapist or treating therapist does not have that there is no privilege when there's in court testimony, because there's mandatory reporting. And so, but it's a really good discussion. I'll put the case in the chat so that you guys can have access to it. But I think that's a good place to start, is starting to analyze when you are presented either with admitting or objecting to mental health expert information, as whether or not, I think it's a good foundational block as whether or not it's privileged information. And obviously you want to always look at whether or not there's Fifth Amendment protections with your client as well. But I'll go ahead and either put it in the chat, or Susan, I can provide it to you so you can include it into the PowerPoint.
Sure, great. So, okay, all right. So these are some more goals and questions to ask and what to look for in mental health testimony. So, again, I guess that my viewpoint in this, my goal in this was to think about what am I hearing that doesn't feel right or doesn't feel enough. Opinions are given, facts are given, but the ability to take that and to interpret it, to assess it into something that means there's something real about the client, is sometimes they just assume they'll say something and they assume that what they're saying is sufficient. And if not challenged, then it's true, then it's left true. So this is we talked a little while ago about difference between expert and practicing. So you know that, I mean, you knew that anyway. I wrote this in part for me to be able to understand differences in the legal terms from what it is that I would do as a provider. So the other thing that's clearly always got to be, and I know even from my work, from listening to the social workers and going to the social work meetings, the contrast and the disparity and the differences at times between what mental health professional might say about a client and what a CYFD worker might say about a client can be very different. And certainly from the side of pro client versus against client, that would make sense, because I mean, if it's a contentious case, like John said, you're not going to be have dueling witnesses if it's a fairly like, yeah, okay, we're going to return the client. So I don't really know what percentage. That would be an interesting question, John. You may not know it off the top of your head, but what percentage do you think of the work in this program gets to this point where it is, dueling witnesses, where it's you bring one, they bring one, and it's very contentious? Do you have a sense?
I wouldn't have a sense of the percentage. I mean, clearly it happens. I think that within the program structure, usually we're able to vet this out prior to it getting to a trial, but certainly it happens on a fairly regular basis. I want to say the majority of the time, but you want to make sure that, again, that's why you have to, it's really case by case. I had started this by saying that I don't want to just put a bunch of checklists on things that everybody should be doing and things that I don't do, but I know I should, because that doesn't really serve any purpose. But I think on a case by case basis, you need to be able to evaluate, is this going to be a case where my client, the cards are stacked against them because of the allegations or because of the plea. That this is going to be a case where it doesn't matter what my client does in treatment, the department is likely going to say it's not going to be safe to return the children home. In a situation like that, you're probably going to want to get a jump start on getting the contact for the therapist, making sure that you are asking the therapist for at least monthly reports or check-ins to your office, to yourself. You check in with them as well. It's a great way, and kind of to address Kristen's earlier question as to how do you get an independent look at this. The therapist needs to understand that there is a court process to this, that the court order is reunification. You're going to get that early on, and a lot of therapists are not aware that there is a plan for reunification. It helps the therapist get a target so that the provider knows that we are working towards this from the very beginning. You get them to start organizing their thoughts. You get them to start organizing how they're doing, how the progress is going. When you have that contact with them, I found anyway that when I've done that, is that the therapist is more goal orientated with my client, as opposed to saying, we're just kind of going through the motions and I'm getting all my information from the department that may not be encouraging or informing them of the court ordered plan, which is why, I mean, this structure works well. You want to have the social worker also communicating with the department so that you get as much communication going as possible when needed. But the therapist really needs to be part of that discussion. And so anytime you can get them to provide you with emails, reports, even if it's not disclosed information. You don't have to disclose that information if it's, just how's my client doing? Are you guys working towards reunification? Is there progress being made? All of that is going to help ultimately, I think, mitigate the need to go to trial, because obviously you'll be better equipped to go into FCMs or pre-perms or perms with what you need to be able to steer this towards reunification if it's appropriate. But I just wanted to highlight that that we talk about percentages going to trial. That's not always a good measurement in terms of how things are going for the clients. It's really more about whether or not the attorney is assisting, that the social workers are assisting in getting the right information to the right people.
I would suppose that even though this is sort of focused on the court and the witness, the testimony, which implies court, I guess, the truth is all of the things that we're talking about in terms of what you want to ask, what do you want to know, what they're doing, those would be things that you would have in your head anyway, and going to discussions, to family meetings, to whatever all the different things you do when you're going to, before it ever gets to court. There are opportunities to listen to what's going to be presented, probably, and to listen to the quality of the assessments that are going to come your way, I would guess. So
that's right. And I mean, I think I saw Mary Ann's name on here, but she knows from a case we're working on, is that sometimes if you get too late into it, the therapists are saying, look, we're way too far into the process and we can't move in another direction anymore. We're too far down the road. And so we can't put this thing in reverse and try to work towards reunification. Sometimes therapists are not aware that reunification is an option. And so, again, you just want to get really early on those cases. You really want to get early on with those treatment providers if possible. It's definitely with your clients' treatment providers. I don't know if you can do much in terms of getting access to the guardian ad litem or to the children's therapist to help them understand that. But again, learning those modalities is so crucial, and make sure that you're relying on those social workers to help explain that. And make sure that the department's workers are familiar with those as well. I think it's just important for everybody to know what modalities are being used for your client to try to resolve these issues and mitigate the concerns.
well, what you're saying just made me think about the fact that we really haven't even used the words, child therapist, and it's often the child therapist that might very well say no, go home, right? They often are the ones that will say too much damage, not ready. We're going to talk about that in a second here, but and I don't really know how much contact both the attorneys and the social workers are able to have with the providers for the child. I mean, I guess somebody has to have a release of information. Is that something that happens? Do you guys ever have access to that person?
I mean, no, as a respondent attorney, you don't have access to that person, but you can have access to the people who have access. And
right.
it's just, that's part of that cross communication.
And the social workers might be able to get access by getting releases, right?
That's correct.
Catherine, any social workers want to speak up now?
Yeah, so we do get access to those clients or to those therapists, more so if the children are involved in treatment foster care. It's an easier hill to climb there. But if they're outside of treatment foster care, it's usually more difficult to get in touch with the children's therapists. But we do utilize them as much as we can.
And as Kristen stated in the chat, I mean, there are the one-offs. I mean, you can get an interview, but in terms of having ongoing access or updates, it's limited as Catherine stated.
Well, and since you are the attorneys for the parents in the program, right? I mean, nobody in the program is attorneys for the children, are they? They're the parent attorneys, right? Okay, well then that was something I was thinking about later, but I guess here I'm going to date myself by saying, some of what I was thinking about in doing this outline and doing this presentation was, how do we I think there's a dearth of high level skill in child therapy around here sometimes. And I think the questions that I would want you to look at, I guess you really don't have much option for, you don't really have opportunities for challenging the decisions of the child therapist unless they end up in court, which they don't often do.
Right, but that goes towards, you know, kind of what I was speaking to earlier. I mean, you do have the ability to challenge that, but I think it's also a communication issue in terms of making sure that your client's providers are knowledgeable of that. You have the cross releases generally between the children's therapist and your client's therapist, and there should be a constant dialogue of whether or not all parties are aware of reunification.
Okay.
So this is Leslie. If I could jump in too, I mean, you just have to remember also that that all counsel are entitled to all reports from any court-ordered treatment. So if the child is in therapy as part of their treatment plan, then as the parent's attorney or the parent's social worker or parent mentor, we have access to those reports. Now, again, that doesn't mean chit chat with them and get updates that way, but we definitely have access to those reports. I think the big problem is making sure that they're requested. And then my other thing is, you know, the minute that they put that person on a witness list, then absolutely you have access to them. To interview them, and then, you know, if you want to actually even have it, you know, a formal interview or deposition, if you're looking at a TPR or something like that.
Mm-hmm. Which also means then that you want to be able to really understand and interpret what you're reading in those reports, because a lot of stuff comes between the lines. A lot of what's missing or inaccurate or insufficient is not always so clear, right? So, but that's very helpful.
And Mary Ann, I saw your hand up. You have to unmute yourself. It's been a year of doing this. Come on, Mary.
Thank you, Jared. I couldn't live without you. So can you send this outline to us, or somehow can we have access? Okay. And then the other thing is, I wanted to say, no matter what, whether you have access to the therapist or not, whether they're an expert or not, for me, the overarching problem is that a lot of child therapists will say the child cannot go home, and that is with no contact with the parents, which is making, well, I won't say it in Italian, but it's making kind of a decision without criteria. So I think the thing that you offered today about some of the cross-examining things, what tests they used, et cetera, maybe to use that to discredit, because this has been going on for years. I do not think you can make a decision as to whether or not children can go home or not if you haven't worked with the parents. And the courts buy into a therapist's position on the child without that. And that has frustrated me, because I just don't, you know, unless I'm missing something, I don't see the rationale for that. No matter anything else, I think that the best thing was a couple of tools that you gave us today with some of the cross exams and some of the, you know, confrontations of the therapists to maybe not discredit, but maybe to at least investigate what they are doing to hit the major problem, which is them commenting about a kid going home without any contact or therapy or observation with the parents.
Right. Which
I'm sorry.
Well, I was going to say that speaks then to also what is the therapeutic modality they're using, because they are just simply doing child therapy. They're not doing family work. So we're going to get into this in a minute. We're going to keep going. John, did you want to say something before I keep going?
No, that was exactly what I was going to say. Yeah.
Okay. All right. So you also may remember that Dr. George Davis came to speak to us on ECHO a while back. And that I believe was more medication related, I think. But the truth is that any kind of treating person has to be able to have treatment plans. So when you're looking at even like the reports that come from the other providers that you're looking at, so does that provider discuss treatment plans with both intermediate and long range goals? Are they using, what are they using? Are they using least restrictive interventions, and what's the rationale for the treatments? Are they experienced with judicious use of medication for both adults and children? And the issue of the treatment for a broken heart is not another medication. That should be stamped on everything. But because, as we know, And as Dr. Davis had pointed out in his work, children who are in care have so many more medications than children who aren't. I mean, obviously that's simplistic, but there are children who are not in care who are also traumatized and have all kinds of mood disorders. But the research shows that children who are in treatment homes have more medication. So that's just something, and I guess that might be more of an issue for children attorneys who are working with guardian ad litems and things like that. But I just want to bring that up. So
Yeah, and this summary here is kind of your guiding light to your contact with your clients' providers. This is what you want to make sure is being done, is being discussed, and is being worked on throughout the course of the case.
Right.
This
Can
summary
they do that? Right. Can yours do that too? I mean, yours have to be able to do that too. And so that's where you impact. Where you're knowledgeable. That's where that substantive knowledge and relational knowledge come together, and you make an impact on who you're talking to when you can articulate data, which is this, but through the lens of a client, and that's relational. And I just think that's got to be more effective as a litigator and as a social worker. So the last thing here is, can your provider, this is interesting, this is in terms of maybe your provider talking to their provider, can your provider challenge another provider's opinion with material from the DSM? Again, the diagnosis statistical manual. You can go, if you're doing good therapy, you really have to have past tests on the DSM. But sadly, I'll tell you, most don't. And so a person who's really skilled in understanding this manual can challenge, well, why is it that you thought blah 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 was what had PTSD as opposed to something else? I mean, there are so many similarities between the mental health categories, but there's also so many differences. And the timing of when mental health issues show up can mean it's this versus that. It's very complicated little network. It's like a little den of vipers and snakes, if you don't like it very much. But anyway, so that's a pretty big skill. And I think you want to know a little bit about what your provider's capacity of using and challenging that DSM manual is pretty big in my boat. So I'll move on unless there's any questions about it. Okay, so the next slide is, come on, we can do it. Where'd you go? There we are, 7. Okay, so this is a do they, don't they question. So do they or don't they, whether it's yours or theirs, have experience and training in areas of child and parent welfare? That's both. So the issues of the strength of attachment versus the necessity to sever that bond. These are all obviously things. You guys have been doing this for many years. And I know that those of you who've been doing it for many years, that you live and breathe this anyway as attorneys. But I wanted to kind of put it into a consolidated form. So in the foster home, reported disruptive behaviors, moods, nightmares, regressions to younger developmental stages. We all know that happens all the time. And it may be more related to the trauma of removal and adjustment to suddenly different situations than it is a reaction to the parent actions. They have a new authority and caretaker. All these things are new. So now I get to use my high school Latin and bring up the concept of iatrogenic problems. I hope maybe many of you know this, but I love this word and I like to be able to talk about it. And it's actually stolen from medicine. So iatrogenic is, a lot of times parents are being blamed for what someone is seeing in children that are not related to the parent, but are related to settings that perhaps in the foster homes. Things like around visitation. The trauma of separation is going to show up every time there is visitation. And yet, how many times I hear the social workers, and in my earlier years of working with CYFD treatment foster, I was a therapist for many years with kids in treatment foster agencies. So that behavior is blamed on the parents. It is not seen as a accompanying trauma that's part of this whole business of taking children out of homes. And so there are two kinds of iatrogenic. I mean, one is like the doctor messed up so bad by leaving a sponge inside the person when they took their appendix out. That's obviously, bad practice, versus there are illnesses that come from other treatments that come because of the treatment. Like the physical analogy, meaning some kind of like a cancer treatment may very well make a person sick, but without the cancer treatment, that person dies. But they also live with other illnesses because of it. So the same idea exists in this work, but too often those things that people see about the children get blamed on the parent. Well, and sometimes they may be related to parents don't show up. Well, that's clearly not just something that is a side effect, but that's a parent not acting properly. But that doesn't happen to all. That's not true of all parent visits. But children who are visiting parents are going to show all of these developmental gaps and delays because of the re-traumatization, small t maybe, of each visit brings the separation again.
Susan, I just want to chime in real quick and just let everybody know that it is 12:57. If you wanted to sign off at 1 because you're here on your lunch break, just a reminder, but we are going until 1:15.
Okay, and this is on the drive, and it could be sent. I can send it to anybody who needs it, but it is available on the Echo Drive, so you can get it that way. So some of this is just repetition of what you already know, that the rage and the regression that you see in children is consequential at times from the actual removal, but then you parents never get away from being blamed for the removal. So it's a mess. I know this is your area. You see it all the time. So there's a little citation of this about traumatic, neglected transition. These taking children away from homes create additional burdens and traumas than from whatever was going on in the home. All right, so this is the last sheet. Does that provider have identifiable experience in family therapy? We just talked about this, Marianne, thank you. In not just child work. Do they have experience in areas of disability, whether it's the children or the parent, regarding issues of reasonable accommodations to increase the capacity of the parent? That there are so many people who have hidden and not hidden disabilities that you have to be able to understand the capacity of the client, whether it's the kid or the parent, to be able to articulate pretty meaningfully what you're assessing. So the last thing is there are these areas are play therapy, sand tray, and art therapy. These are so common modalities working with children. But in New Mexico, there are no licensing. It is not licensing for these. These are not therapies or capacities or skills that are licensable, but they are very much available certifications and trainings. And so if you've got somebody who's a child therapist, perhaps saying, nope, they did this in sand tray, therefore, nope, they just cannot go home yet. I would be curious to ask what exactly their experience in training for this is. Because as I said, there are several trainings available and they all lead to a qualification that is identifiable to be able to say that they're skilled in these areas, as opposed to they're just simply using them. They're using these media, but they have limited theoretical foundation. These are all deeply theoretical. There's the deep and clear methodology and meaning and interpretation on each of these things. But in the hands of somebody who just does it, but isn't really skilled in the understanding of what they're doing, that's bad. And I think this happens a lot. So I think this is something I would challenge child therapists, or maybe even adult therapists. Adult therapists use these too sometimes with adults, but they're mostly kid-related therapies. And I challenge their capacity, how have they learned to do this, and how do they base their interpretations on what's the theory of each one of these things. Okay, so that really finishes what we're doing here. So is this okay? I'll take it off, stop share, and we can, if there are questions, right? Anybody? Is that okay? All right. So I'm good to stay around. It's 1 o'clock. So does anybody have some questions or comments to bring on? Bring it on. Or I did not follow the chatting at all, so I have no idea whether there were chats that were wanting to come forth.
I've been monitoring it and there really hasn't been a lot.
Okay, well, I'll talk again then. So, with regard to the child experiencing trauma, there's not, in my 17 years of doing this, there is not one situation where I haven't seen that the social worker and the therapist talk about how the child responded, that the kid basically fell apart after a visit, or that the kid's behavior, well, I'm sorry, I need to be formal. The child's behavior was much better after visitation stopped. And I tell you, I've asked and asked and asked experts on the stand, well, what about the idea that they got yanked away from their parents? And that argument, 99% of the time, I've never made any headway. They'll say, well, maybe, but all the statistics and all my research and all my study points to this. And they'll go right back to their idea that the child is traumatized because of what the parents did. And if the child's doing well, it's not because of what the parents did, it's because what happened in the foster home.
Right.
And it's very frustrating because I think I've lost many TPRs in my life based on that. And, you know, there are some TPRs that still bother me that I think that I lost because of these situations. And it's interesting that after all these years, you bring that up as still as a problem. I mean, I guess it makes me feel better and worse at the same time.
Well, I think that's also why you want you want your practitioner to be able to offer alternative explanation. I mean, that's just the only solution to that. And it won't solve it all.
Yeah.
But there are alternating explanations. And again, as I said, you could go through here and find all kind of reasons why that behavior is there,
Right.
that at least need to be put forth. So challenging with an alternative explanation is big. I guess that's the whole cross-examination or whatever business that you guys do, right?
Well, thank you.
Are there any more questions, comments? Okay.
One comment I would make is with their experts, the first rule, and it's 11702, they have to be qualified, which they usually are, but their testimony also has to assist the fact finder in a way that a layperson can't. And I think sometimes we forget about that. Just because this doctor's a doctor doesn't mean they automatically qualify as an expert. They have to have something there that you know, they can't, there's gonna be medical records, anyone can do that. So there has to be something that they offer that a layperson can't, that's at issue, that's gonna assist the judge in making a determination. So I think we stipulate to these experts on a regular basis, like Dr. Strickler, et cetera, when they might not actually have something that's going to assist the fact finder, but they're a fancy doctor who says all this fancy stuff and they get in as an expert when they really shouldn't. So I'm guilty of that. That's just, and I think that some of my colleagues are as well, but we need to be more aware of that and fight that issue in the future.
Yeah, well, I think that's a good point. And I think you brought up, was it 702? That was the expert rule.
It's 11702, and there's a bunch of civil cases on that, but they have to offer something.
Right. And then the rule right before it is 701, and that talks about, you know, just your lay witness and what they're able to testify to. So you can always look at that to kind of base your objection as to whether or not their testimony is just really rationally based on their perception. Yeah. As opposed to requiring, you know, scientific or technical skill. I think we've all been in court where like a visitation monitor or supervisor is trying to be proffered as an expert in child or bonding or child relationships or whatever it may be that they try to squeeze the expertise into. So yeah, definitely don't want to just bow down and stipulate to those.
So Ms. Burns, can you give one example where you cross-examined an expert or even a lay witness with regard to this business with the children or the, oh gosh, whatever the other thing I talked about is, and spun it in a persuasive way to the court? I mean, it's one thing to cross-examine and say, well, yeah, well, and then argue, well, you know, the methodology that they used didn't work. So how have you successfully spun it to the judge, or the
Well-
lawyer spun it to the judge as a result of your?
All right, so I myself actually have not been engaged in court very much.
Okay.
So as a mental health therapist, it's just not something that I've been, although I had back in my days of working with CYFD cases, I did some. And I believe that as I said earlier about the combination of the substantive data-based professional understanding and the relational based awareness of the client and the context, that if you could blend those two together and make that person be more real and their work toward their struggle towards improvement in the context of bus passes and I mean all the obstacles are real, but the relational work that comes from seeing their struggles real. I think obviously I don't know the court the way I don't know court. I don't know judges and I don't really know the work of the attorney, but it seems to me that that creates the possibility of being heard better. And I think that the more a person can break down, I guess this comes from also being a teacher for so many years, and that, the jargon involved in any business, any profession is obnoxious, but it can all be broken down into pretty identifiable, simple, understandable ideas. And so I have been involved in depositions before where people are saying, well, isn't this person just sort of practicing a religion, blah, 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 and wanting to, and I would go through, well, there's Kohlberg's, Kohlberg's theories of moral development. There's the standard Maslow, Erickson, all the basic theories. But if you can break down something and instead of just attacking it, if you can present why this feels like alternative explanation is more effective, then that's all I can offer. So I guess I'm talking and I'm not sure I'm saying anything. So I'll be done.
That's fine. Thank you.
So I've got an idea. I think won cases when I asked the department's witness, particularly say in those bonding study where we're comparing the foster parent and the biological parent. Frequently, they've done bonding studies on the foster family and the kid. And that's it. And one of the most effective questions that I used in more than one trial was, you don't know anything about how the parent and the child are connected, do you?
Mm. Yeah.
It would have been useful for you to have interviewed the parent in this context, wouldn't it have? I don't know that I'd say it exactly that way, but just challenging, what's the limited information that they have?
Mhm.
They got part of the way, but how can they possibly know the comparison if they haven't had all the information come in that they need?
And any credible bonding study is really evaluating the child's ability to bond. And then so that's what you really want to focus on, of course, with any bonding study, is that this child is actually able to bond. And you want to connect the dots again to using your client's own providers and in terms of establishing him or her as a safe and appropriate parent. That bonding study actually should, even if they haven't evaluated your client, would go really nicely together, because the child's ability to bond, coupled with a permanent and stable caregiver, safe caregiver, all the findings of the expert witness on the bonding study would be able to apply to your client.
Kristen, I wanted to ask, does Corinne Wolf still have a list of expert witnesses that are available for consult?
That list was 15 years old. And I went back and tried to find some of them, and I couldn't find most of the people we'd spoken with.
Yeah, that's too bad. It wasn't in a mental health context, but I do think that the research is out there. And that was part of my thought is if you, hopefully if you can, I mean, this is a great place for us in the New Mexico Family Advocacy Program to rely on our social workers, is having that knowledge and knowing, you know, what are the latest things, that treatises that have been written and published? What's the latest, you know, peer-reviewed study about that kind of thing? Because I have actually been able to ask an expert witness, do you know about this study? Do you know that this study says this, you know, rather than what you're saying, and that it's based on whatever. And so when you, like, we often don't have the resources to have our own expert witness come in, getting that kind of information to challenge their expert opinion can be helpful.
And that's good point, Leslie, because I think that also goes on, I know that there's been trainings on this as well, but in terms of the structure of the program and what it is that really how every team member is to be, you know, benefiting from one another's knowledge. And so just make sure that the attorneys are aware that you have a great source of knowledge in terms of all of this on your team. And they are available to help explain modalities and how they work and what modalities may be more. It's not just what treatment would be better for your client, but also understanding these modalities. So please make sure that you're taking advantage of that. And again, with the chat, you know, Brian had a thought for Mary Ann, but again, that Ire is really beneficial. You can use your team, you know, use that social worker to help understand that, and you will have a much better exam of that expert when the time comes. And that goes to Brian's point.
And also in the chat, Raina suggested the book Don't Hit My Mommy. I haven't read it, but I guess I need to. But thank you very much, Susan and John. Very informative today. We really appreciate it. And please, if you can take a few minutes to fill out the survey, we would appreciate it. And hope everyone has an amazing day. I put my stuff away. So Leslie, do you know when the next echo is?
Yes, the next didactic session is April 13th, and it will be on the use of visitation hosts and alternatives to supervised visits. So that should be good.
I
Okay,
want to
thank
put
you
in a
all.
quick pitch for Don't Hit My Mommy. That's one of the key books that the child and parent psychotherapists and the folks involved in the infant mental health program use. And so if nothing else, it's important for parents council to inform themselves of what's in that.
Thank you.
Thanks, Raina. Okay,
Okay,
thank
we
you
will
all.
wrap up today. Thank you. Hope everyone has a great week.
Thanks, John.
Thank you all.
Thank you, Susan and John.